District of Ohio with the Honorable Marilyn Zayas presiding is now in session. Please be seated.
Good morning. How's everyone doing? Excellent. So today's Tuesday, July 15th. We actually have 6 cases that are on the docket this morning. 3 of them are scheduled to argue, of which 2 of them will be arguing together. And we'll start with those 2. Those are cases number 240498, Fenner versus Durrani, and 240499, Schuster versus Durrani. If attorneys, can I please identify themselves and their readiness to proceed?
Good morning, Your Honor. My name is Nathan Coyne.
Good morning. How are you doing?
Well, how are you?
Very good, thanks.
Alan Stabman and Ben Moran on behalf of the appellees.
Thank you for being here. Then we have cases number 240546, 547, in Ray GT. If attorneys can please identify themselves and their readiness to proceed. Good to see you. And thank you for being here for Attorney Wessel.
Sure.
Then the remaining cases have submitted on the briefs. They are cases number C240621, State of Ohio versus Norman Johnson, C240695, State of Ohio versus Dante Jeffries, C240574, State of Ohio versus Charles Mosley. Alrighty. All right, so good morning again. You can come to the podium when you're ready.
Good morning, Your Honor.
Good morning. Would you like to reserve time?
Yes, 3 minutes, Your Honor.
3 minutes. Whenever you're ready, you can get started.
Thank you, Your Honor. Good morning. My name is Nathan Coyne, and I represent the appellants in this case. May it please the court. Mr. Pridemore reported, "This is the best I have felt in a long time." He reported that to his physical therapist after surgery with Dr. Durrani. Mr. Pridemore benefited from surgery with Dr. Durrani, and if his case had been tried alone, Dr. Durrani almost certainly would have prevailed. But his case was not tried alone. It was tried as it should have been and as is the norm in our system of justice. Instead, it was tried with the case of Miss Reeder, and it was allowed to survive based on the unfair prejudice that resulted from their joinder. Plaintiffs built their entire case on propensity evidence. Dr. Durrani did it there, so he must have done it here too. But that type of evidence is forbidden in our system. It is prohibited under Evidence Rule 404, and it is prohibited for good reason. Each case must be tried on the merits of that case, based on the facts and evidence that are particular to that case. In Mr. Pridemore's case, the evidence showed remarkable improvement. Before he went to see Dr. Durrani, Mr. Pridemore, he walked with a cane, he suffered from jerking sensations in his arms and his legs, he was taking pain medications, and even with the pain medications, he was describing his pain as 7 out of 10. After surgery with Dr. Durrani, he was no longer walking with a cane. His jerking sensations had been greatly reduced. He was off pain medications, and he was at a 0 out of 10 pain. He told his physical therapist that this is the best that I have felt in a long time.
Can I ask procedurally on this? The cases, there was prejudice argument that was conducted in I believe it was the Denzler case when they decided to try always try 2 Durrani cases together. Was this argument re-raised in front of the judge for the 2 cases that we have on appeal now, or was this just argued back with the Denzler case?
Yes, Your Honor. And while we believe that arguing it back during the Denzler case was still preservation for this issue.
But it really was not a specific argument. What you're making right now is very specific, and back then it was more general, like you could never join these two cases together. Was this specific argument raised?
It was. I'll put you to TP Volume 2, 189 to 191, where the issue of prejudice in this case was specifically raised.
And what you're saying now about how this particular Mr. Pridemore benefited from the surgery and everything.
Well, that would be impossible to raise before trial because that evidence hadn't yet come in.
You had discovery.
Well, yes, but we don't know what argument the other side is going to make until the
Okay.
other side actually makes it. So at the beginning of trial, we argued and preserved the issue that there would be unfair prejudice as a result of propensity evidence that would come in as a result of joining these cases.
And that's going to be the case. I mean, your argument basically, and has always been, that you can never join two malpractice cases together. Is that your argument?
Twofold, Your Honor. We believe that, but we also believe even if you could, in certain circumstances, in this particular case, there would be unfair prejudice that would result from joining these two cases in particular, which was preserved at the start of this case.
At the start of this case, meaning before this trial, how was that precisely? Was it by motion or was it in a separate hearing?
At the start of day 2, before opening statements, there was a conversation with the trial court, and that this specific issue was specifically raised at that point. The trial court overruled the objections. It did not make particular findings of fact, common issues of law or fact that it was based on. It was based on efficiency.
And at that point, though, you knew that the Pridemore plaintiff had a much better outcome, or a worse outcome, I guess, than the Reeder plaintiff?
Well, our argument isn't that Ms. Reeder didn't improve. That's not what we're saying. We're saying that in Mr. Pridemore's case, as an example, and also in Ms. Reeder's case, the case wasn't a strong case, but it was allowed to benefit from the fact that it was joined with another case. Propensity evidence was allowed to take a weak case and make it into a strong case.
And what exactly from the other case made it stronger?
In addition to half the trial being dedicated to another case that was not relevant to Mr. Pridemore's case, there was also, in closing arguments, what was described by plaintiff's counsel as the nuclear bomb of this case. And that was a note written by a nurse, and in that note it said, unfortunately, had surgery with Dr. Durrani. That had nothing to do with Mr. Pridemore's case, and yet it was allowed to be their nuclear bomb in his case. And it wasn't argued specific to Ms. Reeder in closing either. It was used to argue that the entire local medical community knew what Dr. Durrani was up to and wouldn't ever touch his case with a 10-foot pole.
Where did that note come from?
I'm sorry, that note was a nurse's note, and it was from Ms. Reeder's medical file, and it came shortly after the very public indictment of Dr. Durrani.
What was exactly the prejudice argument that was made that preserved the error for us?
The
In other words,
argument.
what was exactly, as exact as you can be under the circumstances that I know it's thousands of pages and so on?
I appreciate that. The exact argument was that there would be propensity evidence that was brought into this case. It was a propensity evidence argument.
A propensity evidence with regard to, because the trier of fact would be hearing about multiple cases or beyond that?
About multiple cases, correct. So every bit of evidence that is specific to Ms. Reeder's case is irrelevant to Mr. Pridemore's case and prohibited under the prohibition against propensity evidence.
So it sounds like that was basically a general prejudice argument.
I don't know if I would call it a general prejudice argument. I would say it's about the specific issue of propensity evidence.
Propensity because of the joinder, but whenever there's joinder, then there's always going to be prejudice. So that's what I'm trying to figure out, because whenever there's joinder, there's prejudice. Can we agree with that?
I'm not sure I would agree with that, Your Honor. I think there are specific examples that Judge Bach explained in her concurrence in Courtney v. Durrani,
Okay.
where that wouldn't be the case. I think a perfect example would be where two people are walking through a crosswalk and they get hit by the same car, and the question is, was the light green? Was there a walk signal? The facts are exactly the same for both cases, and both would be testifying at the other person's case. So joining the case in that case wouldn't cause any prejudice. But here, in this case, you have two different surgeries in two different cases for two different people. And under those circumstances, you are using propensity evidence in order to make the case.
So it sounds like maybe what you're saying is in a medical malpractice case that there should never be jointer.
I believe that would be the appropriate.
The surgery
rule.
doesn't happen to two people simultaneously, obviously.
Yes, I believe that is correct, but even if this court doesn't even need to go that far, it can look at this specific case and look at the unfair prejudice that occurred in this specific case. And one of the key examples of the biggest proof of unfair prejudice in this case is the identical verdicts. In Courtney, this court pointed to the fact that there were not identical verdicts and said that that was evidence that the jury could see between the two cases and parse them. But if that's true, then the opposite must also be true. And here, where there's identical verdicts, that's evidence of the fact that they were viewing these two cases together.
In the time you're remaining, do you want to address the set-off?
Yes, I would. That's an issue that was never responded to by the opposing counsel in their briefing. But that's an issue that I think is very important for this case to consider because there is precedent from this court, but that says that a set-off would not apply in these circumstances because it's an intentional tort. But that precedent is based on an Ohio Supreme Court decision that has subsequently been superseded by statute. And I think this court can recognize that that superseding has occurred and move forward on the new rule, which is consistent with the statute as modified, which says that essentially you can't have a double recovery. Even if there is an intentional tort in any case, you can't receive more than you were awarded in the verdict. And that's exactly what happened here as a result of these settlements. There are two points in the plain language of the statutes. The statutes are 2307.25 and 2307.28 that I think compel this finding. The first is 2307.25, which involved the right to sue another defendant for contribution. That says specifically, except as otherwise stated in 2307.25 to 2307.28. Now the other statute which concerns set-off is 2307.28. So by the express terms of 2307.25, it is saying that 2307.28 goes above it and matters above it. But even beyond that, 2307.28 was modified after the Ohio Supreme Court's decision in Jones to add a clause at the end stating that in any case, you cannot recover more than the jury verdict. I think that language was there to supersede Jones, and by the plain language, that means that in this case, a set-off would be warranted.
And what legal effect under the appellate rules would it have, the fact that the appellee has not responded to that particular assignment of error?
I think it would result in waiver of that argument. It was never raised. There was no briefing. The defenses against it have been waived, or forfeit, I suppose more accurately.
And on remand, the set-offs, would they affect the prejudgment interest calculation also?
I think that that's a separate issue. The prejudgment issue is really a question of whether there was a good faith settlement offer made by plaintiff's counsel, and I think that comes down to a matter of simple objective math. Their settlement offer was for $1 million per case, which was a whole house away from the best day in course they could get, just based on the mathematics of how much their compensatory damages were and how much punitive damages would be capped at as a result. So under those circumstances, there was no way they could ever get $1 million on their best day in court, and therefore a settlement offer of $1 million would not have been a good faith settlement offer. The other damages.
Now, on your past medical expenses issue, you raise an interesting argument on the statutory cap on punitive damages.
That's right.
But you don't have any challenge in your appeal to the punitive damage award. I don't believe that's an assignment of error.
Well, two things on that, Your Honor. The first is that the final assignment of error is about the total damages calculation. We're saying that whole damages calculation was wrong.
Okay.
I think that would include the punitive damages. But beyond that, Your Honor, the argument that we're making is that the remedy that the trial court made was not unprejudicial. It wasn't a harmless thing to say that, no, we're just going to wait until the insurance company signs off and says, yeah, we're not going to pursue this claim and you can pursue it for us. That's not harmless here because it resulted in them allowing them to have more punitive damages than they would otherwise.
Did you only get the punitive, the cap is based on what they actually get?
That's right. It's based on compensatory damages. It's twice compensatory damages. So if there's $33,000 in past medical expenses that they're not entitled to in the first place, they're now getting an extra $66,000 in punitive damages that they're not entitled to. And so that's the prejudice that results from not saying punitive damages are off the past medical expenses are off the table here because it's not your claim. You don't have standing to pursue it.
So on remand, the calculation would be take the set off, reduce the total compensatories, reduce the punitives, reduce the prejudgment interest.
Eliminate the prejudgment interest. But yes, that's correct, Your Honor. Well, I think the first request would be for a new trial based on the other issues, the other assignments of error. But even if this court were to say we're not giving a new trial, yes, it would be to reduce the damages, correct.
What happens with like Medicare, because you can't force Medicare into the action?
Yes, Your Honor. So in that case, the trial court was required to consider three factors, one of which is the prejudice of not having them at the trial, and whether that prejudice can be reduced against the defendants. And that goes again to the issue of the punitive damages and how the cap was increased as a result of this. In order to truly remedy the prejudice that would result, you would need to say, we're going to pursue this claim further, but we're going to remove past medical expenses from the equation, period.
For the punitive damage cap?
That would, yes, that would mean that the punitive damage cap would also not be damaged. That would be the way to remove the prejudice. That's not what happened here.
Thank you for your argument.
Thank you, Your Honor.
Good morning.
Morning, everybody. Deja vu all over again.
That's
Can
okay.
you start with the set-off argument?
Yeah, that actually is where I was going to start off.
Great.
Because I think you're putting the cart before the horse, talking about a remand. Since there were punitive damages and a finding of fraud, they don't get a set-off. And that's clear in the law. So this talk of set-off is inappropriate. Doesn't exist. They don't get it.
Well, wait a second. You're saying it's clear in the law. Which law?
The Ohio Supreme Court, I don't have the site in front of us, we've cited it in other briefs. I didn't realize that it would still be an issue after other rulings, that if there is a finding of fraud, a litigant doesn't get the benefit of their bad acts from money that comes from other places.
Well, what they're arguing, though, is that these cases have been superseded by statute, and that the cases out of this court were wrong. And they point to a federal case that gets into great detail about why we were wrong.
Well,
And so that's what they're doing.
the federal case is not binding upon you.
I understand that, but they point, you're saying that you're relying on these prior cases, but there's been statutes that have come out afterwards
Yeah, I'm
that say
sorry
that you can't get double recovery.
Well, I don't think that it's a double recovery under the Supreme Court findings, and they did not specifically overrule the Supreme Court in finding that statute applicable. For instance, in the case I argued in front of the Supreme Court, Elliott, related to this, when the legislature passed the law that specifically overrode an Ohio Supreme Court decision, they put right in the statute, this statute is meant to overrule the rule of law in Elliott. And so I don't see that language in any statute.
But then how do you reconcile the statute saying that there's no double recovery?
I reconcile it by the fact that this is the problem. When you do things intentionally wrong, there are penalties for doing it, and you don't get a set-off for your intentionally wrongful act. That's my position on it.
Okay.
And we may disagree, but I think that I feel that's been pretty clear.
So, counsel, did you respond to the set-off argument in your brief?
I don't recall. We may not have,
Okay.
because of the previous
And
findings.
if you didn't, what legal effect, if any, does it have with regard to our appellate review of that particular issue?
It's not a waiver. You just decide what the law is. You can't decide inappropriately because there wasn't a response. You can't say, well, whatever the appellant wrote, we decide for the appellant if they're wrong. So I don't think that it has any tremendous impact, other than in our writing, we weren't very persuasive for the opinion that I'm giving you now, but we've written about it a number of times. But I don't think it's a waiver that just gives you the right to decide in their favor. I'd also like to address this idea that there's a propensity issue going on in this case about Dr. Durrani. You have to weigh the fact that there's a credibility instruction, okay? And that credibility instruction gives me, as the trial lawyer, a lot of leeway in talking about the truth of anything that is going on, not the propensity one has to tell the truth or not the truth. And it says, you may believe the testimony of any witness simply because he or she was, you may believe the testimony of any witness simply because he or she was under oath. But you may believe or disbelieve all or any part of the testimony on any witness that you believe is not telling the truth on one issue. It is your province to determine what testimony is worthy of belief and what testimony is not. And it goes on to talk about you may believe all, part, or none. So in closing, I can talk all day long about what I believe Dr. Durrani's truth or untruths are through his testimony. His testimony, which they concede in every trial, are the written records. And the written records establish the credibility.
What about the idea of the nurse's note? The nurse's note in the one case that is, I guess, the nuclear bomb argument in closing.
I don't remember saying nuclear bomb. If it's there, it's there. But
Well, apparently, obviously that would have come in the one person's case, but if the cases were not combined, it wouldn't have come in the other person's case.
Interestingly, the jury instructions are instructive on that. So first of all, there wasn't an objection to that, because if there was an objection, there would have been a ruling, and if the judge thought that that was prejudicial and not part of the treatment record in the past, if that's what the judge decided, that would be redacted. So there appears not to be a specific objection in a ruling on that issue. And that's happened a lot. They find, meaning the appellate lawyers, a lot of errors with the way the defense tries the case. They didn't object to this, they didn't object to that, yet they raise it here. Well, there are strategic reasons they're not objecting as well. And so there's kind of a push-me-pull-you between the people that aren't there at the front of the battle and the people that are. But I don't believe there was a discussion about redaction. But every set of interrogatories has the jury describe what the malpractice was. So first, the verdicts are not the same as they've represented to you. One of the verdicts was $103,519 plus punitives. The other verdict was $94,983 plus punitives.
Were the punitives were the same?
Well, sure they are.
Yeah.
Because the jury determined that was the amount of money under the punitive damage instruction that would deter other physicians and Dr. Durrani from future behavior. And since it was Dr. Durrani being deterred and the community, why would they make separate calculations? It's not related to the compensatory damages. It even says that in the jury instruction. You've done your job on compensatory damages. You are now to consider punitive damages, separate and apart from the award of compensatory damages you've given. And then that jury instruction instructs them. And it doesn't surprise me at all that that would be the same. It ought to
What
be.
what is the prejudgment interest? Is it calculated off the total combined?
No, it's calculated off the verdict separate from future damages. So you take the future damages that a jury awards out, you look at the compensatory award, and then you award that back to the date of the injury.
So the punitives are no component of the PJR?
There's no prejudgment interest on punitive damages.
But on the issue of punitive damages, I'd like to hear your response to their argument that with regard to the past medical expenses and the failure to join Medicare, United Healthcare, and Anthem as real parties in interest, that raised then their punitive damage cap, and that was the prejudice
Well, you
involved.
can't join Medicare, as you pointed out.
Well, I know, but then we just had this discussion when they were up here, when your opponent
That
was up
doesn't
here,
waive-
about how to fix the prejudice piece of
It
that.
doesn't waive their amount just because they're not joined. You just can't join them. And
Well, wait a second. It waives your
Does not waive
client
their
doesn't
recovery.
get, but the punitives are, the cap's calculated based on the amount that your client is awarded.
right.
Right.
And we're awarded that money, which we then have to pay back.
Okay.
And the
So that
judge,
wouldn't, the Medicare piece wouldn't reduce it, but the other United Healthcare and Anthem,
except that money goes back to those providers because they have a subrogation issue,
okay.
interest by contract, and Judge Reese always protects Dr. Durrani from double recovery by saying that if that money comes in, meaning if they ever pay a verdict, which they never have, that money will be sequestered with the clerk and held for a future hearing and distribution. So there's no double recovery.
But what about the punitive damage cap argument?
They're entitled to have the medical bills calculated in there. I don't understand that argument. You've already ruled that Judge Reese has correctly protected Dr. Durrani from a double recovery. You've
Right,
ruled.
but we haven't dealt with this particular argument that they're making in this case.
But how's it a double recovery? It's the singular medical bills.
It's not
in
the
the
issue
case.
of a double recovery.
I'm sorry, what?
They're not arguing a double recovery. What they're saying is that if United Healthcare and Anthem had been in the case, they would have been awarded the money, right? Not your client.
No, they have a right to recover the money through the client.
Okay.
Remember, the way a
So
subrogation
is your
provision-
argument that this has no effect on the punitive damage?
No, it has
cap?
no effect because the subrogation provision says that they are subrogated to the right of the plaintiff, and they collect through the plaintiff. So without the plaintiff in that contract, they would have no right to recover at all. So they don't get a pass on that money because they want to argue, well, that's really Anthem's money directly to Anthem. No,
It wouldn't
passes-
affect, your argument is it wouldn't affect the
It
cap.
has no effect and has had no effect up to this point. This is the first time this argument's been raised.
Yeah.
And it doesn't make any sense since the rights are derivative through a subrogation contract that relies upon the plaintiff in the first place. So I don't see how that is going to work. And let me see if I covered everything that. Oh, this idea, back to your nuclear bomb thing, that it infected both cases. No, it doesn't. I argue them separately.
In closing?
In closing, everything is separate. The jury has a notebook for one case, the second case, and in sometimes the third case, where they keep all the testimony separate. Then when we get up to do opening, we do one case, then the next case. When we get up to do closing, we do one case, then the next case. Punitives, I argue them together because it's my opinion that it's the same amount of money in each case that it takes to deter the public of doctors in Dr. Durrani. So this idea that it bleeds over isn't true because you then go back to these statements which come right from the jury interrogatories. They are asked to describe what the malpractice was. And they don't describe the nuclear bomb, saying even the nurses knew he did wrong. They talk about failed to meet the standard of care, relying on the expert opinion in the MRI. We believe Dr. Durrani recommended a surgery that was not medically necessary. That was their description in the Reader case. And then in the Pridemore case, they said they failed to meet the standard of care. They believed on they went with the expert opinions, MRI, and lack of due diligence in care. We believe Dr. Durrani recommended a surgery that was not medically indicated. They don't talk about what some errant nurse said later. And of course these people came in with multiple injuries, or multiple problems. I've told you all this before. You generally, at their ages, don't go to an orthopedic spine surgeon unless you have a multitude of problems. And a lot of them, sometimes 15 or 20 comorbidities, plus the spine. So it's not unusual. They try to argue, oh, he came in on a cane and he had tremors. Well, the testimony about the tremors was universal. The expert said the tremors were not related to his back. So the fact that the tremors got better after the surgery has nothing to do with it, and that's just a misstatement of the record.
So your position is they're similar enough that they can be grouped this way in almost every circumstance, given the profile of the patient and the fact that the medical malpractice is, depending on the experts, very
Same
similar.
experts, same judge, same plaintiff's lawyers, same 3 defense firms, same legal issues, same and similar factual issues, all very similar cases. And we try to, and you can't get perfect overlap, we work to group the levels of the spine that he's working on. It doesn't always come out that perfectly, but they are all spine surgeries. And then we go a
Whoever
step.
has their phone on, please turn it off.
And then we
Give me a moment,
go
because I want to make sure
a
we hear
step
you.
further.
Give me a moment and let me
Yeah.
make sure that we hear you. Whoever has their phone on, please turn it off.
You go a step further and attempt to group them by areas of the spine, but that's the last element if we can do that. Also, back to the separate nature of the trial, when we try the case, if Your Honor is the orthopedic spine expert, we put you on the stand and we do the first case, direct, cross, redirect, recross, and then we do the second case.
And do you think the juries are able to parse that? It just seems like, just as a matter of, they're already complex cases, right? These are medical malpractice. These are some of the most complex cases juries determine. Do you think, I mean, you've got great experience with this, that they are understanding the different nature of the particulars of the particular malpractice case?
Judge Reese, at the end of every trial, walks up to the jurors and asks them if it was something that they had trouble with, keeping them separate. And that's where the multiple notebooks came from, to make it easier. But they all say that they can keep them separate, and do keep them separate, because verdict numbers can vary. We can win one, lose one, win both, lose both.
Simultaneous, cases that are being tried at the same time. You get like a plaintiff verdict and a defense.
Yes, we get 2 defense verdicts or 2 plaintiffs, or we get a mix of everything. And at the trial level, I started trying cases in June of 18. I've tried 125 cases with Ben. We win 82% of the time. So 18% of the time, there's a defense verdict of some sort. So the juries are able to parse out when they think there is or isn't malpractice.
Thank you
And
for
we
your
have-
argument.
Thank you.
Your Honor, there he goes again with the propensity arguments. It's not about this case, it's about all the cases.
But, again, whenever there's a joinder, there's going to be prejudice, which is why the standard isn't just prejudice. So there's always propensity, there's always prejudice by that propensity, by the nature of joinder. That's why there's a higher standard than just prejudice.
But I think propensity evidence is unfairly prejudicial by the fact that it's prohibited under Rule 404. But again, in
But
this case,
so are you arguing that there should never be joinder in a malpractice case?
I think that you could either conclude that, or you could go on based on this specific case and say, under these facts, there shouldn't have been a joinder because it was unfairly
So why
prejudiced.
don't you argue that? Because I haven't understood your argument that is specific to this case on why the prejudice was not just the prejudice that you're going to have whenever you have joinder, and there's always going to be propensity because of the joinder.
Your Honor, I think it's, again, both. And in this case, we're making the specific arguments about, like, the nuclear bomb testimony, for instance, and that's in TP Volume 8, 1298, and I want to just quote it for you. I cleaned up a little bit of the ums and stuff, but he said, and you know what the nuclear bomb in this case is? The nuclear bomb in this case is Exhibit 45. Here's how the community feels about Dr. Durrani. Unfortunately, had a lumbar disc surgery with Dr. Durrani. Need I say more?
Closing argument,
That's in closing argument, Your Honor.
and no objection?
Your Honor, there was no objection to that specific argument because the objection to propensity evidence.
Well, that seems like a little different than propensity evidence. That seems like not a repetition of some particular bad act. It's like reputation in the community, bad reputation in the community. It seems different than propensity. It seems like a single one-off thing as opposed to a repeated.
He argued it 3 times in his closing argument. I'm highlighting one specific example. And he also, and I have to point out as well, these arguments were preserved at the start, and there are a lot of cases going on, so we try to preserve them at the beginning of every case. But in this case, a lot of the times we're objecting to arguments that were never fully fleshed out by the other side in the first instance. The trial court's not making the findings in the first instance. Even in this briefing before this court, the other side is making all its arguments here for the first time. None of it is in their briefing. And so to a certain extent here, we're trying to do everything to preserve everything to the best of our ability, but it seems kind of like.
Well, we understand it's a challenge. As to the set-off issue,
That's the setup.
in regards to statutory construction, does the General Assembly need to say that they're overturning a specific case when they pass a new law?
No, not at all, Your Honor. At the point that it passes a new law, that law goes into effect. If you're talking about a prior case, that might go to the question of whether it's retroactive or not, and that's going to depend on the specific language. Like if they say this is going to apply retroactively, that's how you know. But once you change the law is what the law is, and it doesn't matter what the court's decision was on a prior law. You're looking at the new version of the law. And under this new version of the law, it's clear that you can't have a double recovery. On top of that, we're not talking about, in that specific argument, we're not talking about the double recovery with insurance. We're talking about the double recovery because of the settlements with the hospital. On the issue of.
Okay. Whoever has their phone on, Ms. Deacon, please turn it off.
It seems there might be an Amber Alert going on.
Yeah, that's what it definitely sounds like. Either that or there's a tornado coming our way, and
Oh,
here we are.
Nobody cares.
Here we are asking people to turn their phones off.
But Your Honor, I know that I'm out of time, so I appreciate.
Well, could you just respond to just get in my brain your punitive damages argument on the past medical expenses?
Yes. So when it comes to the insurers,
How it would lower the cap.
yes, it lowers the cap because the insurers should have been joined as necessary parties. In Pridemore's case, there was a finding a year and a half prior about that. But insurance was not included. And once insurance was not included, because those are, the past medical expenses are not plaintiff's claims, they're the insurer's claims. So likewise, punitive damages on the calculation on the cap should be based on the compensatory damages that are available to those plaintiffs. I can't benefit on my punitive damages cap based on money that's owed to another plaintiff, especially if that other
So
plaintiff
if
has
you,
not
if
died.
you are, if you happen to be insured, then you have a lower punitive damage cap.
Your Honor, no, I don't think that's exactly how it works. How it works is that the insurance gets to bring the past medical expenses argument, and then it can seek double damages on punitive damages for that. But it's because the punitive damages are being calculated based on past medical expenses when we're talking about this specific number. And so if the past medical expenses were not paid for by the individual, they were paid for by insurance, then yes, I think it makes sense that any punitive damages that are based on that past medical expenses should only inure to the benefit of the insurance company. They shouldn't be inuring to the benefit of the plaintiff. For those reasons, Your Honor, we ask you to vacate and set for a new trial. If there are any other questions, I'm happy to entertain them. Otherwise, we'll rest.
So I want to make sure I understand, because now I'm thinking about this punitive damages issue, okay? So let's say we were to agree with you. Who would pay the punitives?
The punitive damages would be reduced because those.
Who will ultimately pay the punitives? Who would be responsible to pay the punitives if we agreed with you?
I'm not sure what I follow your question.
In other
Your Honor.
words, the set-off,
Yes.
it's clear that on your argument on that particular part of the compensation would now go to the insurance. Okay, so are you saying the punitive would also go to the insurance?
Well, I'm saying, Your Honor, that it wouldn't have been proper in the first place to include the past medical expenses.
But
So you
that's-
shouldn't have had either, but you would reduce them both
Because
because,
to me, that's intertwined whether punitives are proper. So if punitives are proper, they're proper, right? So now who pays punitive? If you're saying it's not paid by your clients, then either, if punitives are proper, then, and if it's not your clients who pays them, then who would be responsible to pay the punitives? Are you saying it's the insurance company that's responsible to pay the punitives?
I understand.
Am I missing something?
I think perhaps I've confused the two issues. There are two distinct issues. There's the set-off, and the set-off is about the hospitals and their prior settlement. And that wouldn't be specific to the punitive damages. That is specific to the total verdict award.
Correct.
And then when it comes to the failure to join a necessary party, that goes to the issue of the past medical expenses, and then the punitive damages. The punitive damages, who they're owed to, remains the same. The question is whether too many punitive damages were awarded in excess of the cap. And the cap for an individual plaintiff
Okay.
is based on the compensatory damages that are owed to them.
But it's true that in this case, in all these cases, that the punitive damages are likely not covered by the insurance, correct?
Your Honor, I'm not prepared to take a position on that today. I'm sorry.
All right. Well, thank you. Thank you for all your responses, and thank you for being here in your arguments. Thank you both for your arguments this morning. We'll take the matter into submission and issue a timely decision. Have a wonderful afternoon.
Should we find out if there's a tornado coming? Should we find out if there's a tornado on the way? If there's a tornado coming?
Judge Nestor is asking if maybe we should figure out if there's a tornado coming our way before we proceed.
I religiously turn my phone silent when I'm in a courtroom and mine went off too.
Well, let me tell you, if your phone going off,
Down completely.
in the courtroom is the worst thing that you do in your life. Like, you're good. I think you'll make your way to heaven. So my concern is more of like everyone, needs to have their opportunity to be heard. And so it's very hard to really focus in on someone's argument when you're hearing that in the background. All righty. So on that note, you're not going to be reprimanded or anything like that. Like I said, if that's the worst thing you do, and that's not like, you're good.
Thank you. Good morning, Your Honors, and may it please the Court. My name is Faith Edwards. I'm an Assistant Public Defender appearing on behalf of GT. I'd like to reserve 3 minutes for rebuttal, if I may. So this is the epitome of a case where this court has the chance to act as the transparency mechanism it's intended to be. The court can right the wrong and ensure that a child's life is not endangered by a lower court's abuse of discretion. When a child's very life can depend upon where they are placed at disposition, trial courts should be compelled to consider alternative placement options. Here, that's the exact case for GT. With his significant brain injuries, placing him in a facility after it took both GT's family and counsel advocating for his treatment at 25 separate hearings, and then contrary to the doctor's and probation's recommendations, was an arbitrary and unreasonable abuse of discretion.
Where was he being held? He wasn't being held at DYS
No, he was at Hamilton County JDC.
Right, okay, and that was the problem. They weren't giving him proper treatment there.
Correct.
Okay, what is the evidence in this record that DYS would not be giving him proper treatment?
Yeah, so if we think of Hamilton County JDC as being a much smaller, much more contained, and with much fewer youths than DYS, part of it is extrapolating that to just being another detention facility without, it's not a hospital, right? So this is a child who needs regular MRIs and ultrasounds.
Yeah, but you're just assuming. Was there anything in the, I mean, I look at it as jail versus prison, right?
Correct. Well, and
And jails are not very good.
right. Well, and if you think of the adult system, sure, DRC has hospitals within them. DYS does not. So he
Okay.
can't get ultrasounds and MRIs in DYS.
And that was all presented to the judge in the record about the lack of what DYS was lacking.
Not specifically, no.
It was just a
certainly more broadly.
generalization.
Yes.
How does DYS do, I mean, DYS must have outplacement referrals for people who have mental health conditions as juveniles in the DYS system. They might not have an in-state DYS hospital or mental institution that's a standalone mental institution, but they must have the resources to place juveniles in outpatient treatment facilities.
Certainly, Your Honor, and especially with mental health, like you were just saying, but this is not an issue of mental health. This is somebody who has multiple serious physiological conditions where hospitals, again, multiple MRIs every year, multiple ultrasounds every year. And again, there are alternative placement options, but
Reviewing the record, it looks like they looked for local alternative placement facilities and concluded that there was not a good local alternative placement facility. For example, if they put him on probation in Hamilton County.
yes, there was one specific, they looked to Buckeye Ranch, and that placement did not work. And again, they said it was because of his significant health needs. However,
So the idea was to send him to Indiana and not really even know what Indiana would be doing?
via the interstate compact, yes, that would have been, he lives in Indiana, his family lives in Indiana.
But like, in that circumstance, doesn't the judge kind of lose control of the probation? Here in Hamilton County, the judge knows the Hamilton County facilities, the Hamilton County probation. You put somebody on interstate compact, you don't really know what Indiana or Kentucky or West Virginia is going to do.
Sure, the argument could be made there, yes. At one point, the lower court did ask probation to look into the interstate compact and what Indiana could do, because they were hearing multiple times that Dearborn had the facilities to be able to treat him. And then that's kind of where it was left. They
And there
never
was-
circled back to that.
There was like no assurance, because it's much harder to get information from an out-of-state probation department or facility than a local or in-state facility or treatment center. At least, that's the experience of many people who have dealt with interstate compact.
And again, I think that argument could be made, but it wasn't explored and it's not on the record. And what was on the record is there's some third and fourth hand information coming from the Indiana Probation Department through Ohio Probation. And the the judge asks him to look into it, and then they say they'll address it later, and they never circle back to it at all. And at the end of this, the GAL and probation both suggested and recommended to the court that GT be sent via interstate compact back to Indiana.
Whose responsibility is it to explore every option that's possible with regard to placement?
I mean, we'd like it to be the
I know,
court.
but whose is it? Is there any statutory provisions that cover that? Whose responsibility is it?
Yeah, I mean, via 2152.19, it is where the youth can be placed is within the discretion of the court.
Right, and it has may make any of the following orders of disposition, and it gives a list of potential. But the question is, who has the responsibility to explore? Because it seems to me that that's at the heart of your argument.
Yeah.
Based on the record, based on statements of the bench, a number of reasonable efforts were made. Unfortunately, most of them were made while you were being held at 2020, and I don't believe there's any other choice but to commit you to the Department of Youth Services.
Yes, so, I mean, defense counsel as well as probation usually is giving those recommendations to the court. So that's who is presenting those. The court here was relying upon probation to make those recommendations and to look into those alternative placement options, which I think is pretty
I'm
standard.
misunderstanding the record a little bit. So they explored the residential treatment program at Buckeye Ranch.
Yes.
Which said, we can't take him. And then his counsel and family were asking that he be transferred to Indiana.
Yes.
For probation, but nobody, whether it was the court, probation, or defense counsel, explored any residential treatment programs in Indiana? Like, those weren't even presented as an option to the judge?
I think they're spoke about, but no actual concrete options, correct?
So probation explored it, but did not have the information to provide to the court. My sense of the record is probation was in contact with Indiana, was uncertain about what Indiana provided, and said to the court, look, you can put him on interstate compact to Indiana, or you can put him on DYS. Those are the two options. We don't have a local option.
I guess I would slightly disagree, Your Honor, that I think the probation more so heard from the probation department in Indiana that said we didn't have any placement options for him, and it seems like that's where their inquiry kind of stopped. It doesn't seem like there was much exploration beyond that.
But wouldn't it be on GT's counsel to present the option to the judge and say, hey, judge, if you send him back to Indiana to be with his family, there's also this residential treatment program that we've explored that's willing to take him? I mean, wouldn't that be on counsel to do that?
I mean, I think
Present that option.
Yeah, I think in this case, counsel was more focused on making sure that he was getting the treatment that was necessary at the time, because there was grave concern as to his well-being and making sure he didn't suffer permanent injury or death from the fact that he was missing treatment.
Yeah, but you're presenting the judge with options, and the judge can only pick between the options that she's presented. I mean, it's not her job to figure out a residential treatment program, is it?
No,
Okay.
Your Honor. Well, and they do it, at one point, counsel does say on the record that Indiana has assured us over and over again that they can take care of these health concerns, but no, there is not a specific facility mentioned on the
And
record.
isn't that why she rejected that option and picked DYS, because she didn't know, like, what he was going to be doing in Indiana?
To some degree, it seems like she rejected that option because she didn't want to release him to probation in Indiana, and there's talk about for his health and his welfare is a primary concern that gets repeated at disposition. However, his health and welfare was only really taken care of because of the advocacy of his mother. It wasn't because of this facility. So he finally, again, this is a child who has multiple brain injuries, very severe brain injuries, to the point of where he's missing part of his frontal lobe, has a cadaver artery that requires constant, not constant, but repeated and regular ultrasounds to make sure that that's not rupturing. And of the 34 hearings that occurred, it took counsel and his mother 25 different instances to actually raise the alarm that he wasn't getting the care he needed. And that was, again, with doctors' advocacy as well, saying the same thing, that of these placement options. I think partially also kind of what made this arbitrary and unreasonable is, again, going back to Dr. Bradley's medical report, which stated the setting that should be included. The setting that should include small groups, avoiding or limiting loud noises and bright lights, minimizing background noise, the ability to limit loud instructions and deliver with a low, calm voice. So all of those things that were medically necessary for him to start to be rehabilitated are just things that simply are, counterintuitive to a facility like DYS.
It seems like there's layers to your argument, and this is certainly a very difficult case. So when I read the record, I could see that there were certainly very acute needs that GT has with regard to his own sort of physical welfare, right? And there was, and there seemed to be a good discussion as to what that is, and Mom was a great advocate in like sharing the needs and really pursuing things while GT was in 2020. I know there were a lot of things going on there, and I think, and you alluded to that. Ultimately, as Judge Krause has pointed out, the bench is going to make determinations on what's presented to it. So while I hear part of your argument of like, is really DYS the best place for the health and safety of GT, right? The court also articulated that they were concerned about the safety of the community in making its determination. I don't think this is an easy ask, but like, what is your strongest argument as to what of the error here, of what the exact error was?
Yes. The strongest argument would be that it was an unreasonable abuse of discretion by the court to not take into consideration the recommendations from the doctor, from probation, from the GAL, that are saying this facility cannot meet this child's needs, and that, in fact, without getting his medical needs met is when you are seeing outbursts. So
Wait a second. I had asked you earlier, was there specific evidence that DYS could not meet his needs? And
Yes,
you just said that you all assumed it couldn't. I mean, I would expect there would be testimony from somebody familiar with DYS that would say, okay, Judge, here's why DYS can't meet his needs. Was that done?
No.
Okay. So, I mean, you're just assuming based on that he needs, can't be around a lot of people, can't have loud noises, that kind of thing, that it doesn't meet his needs.
Correct. Given what the doctor's outlined recommendations are things that just truly are the antithesis of the facilities. You can't limit loud noises.
We can assume that unless they make special accommodations for him. If that's we don't know if that's possible.
Yes.
Yeah. Okay.
And we kind of know from the record that maybe he wasn't getting those things at 2020, but to say that he wouldn't be getting those things at DYS, might be to engage in conjecture about DYS's services, because what the opposite of what you said is true. DYS might be much better resourced and have more opportunities for health care and mental health than a local option.
And unfortunately, being kind of strong-armed by the record, we know that not to be true, but that is not on the record before you, so.
Yeah. And I understand your concerns, okay? And I'm sure Mom has the same concerns. I hope you can understand that both, the trial court and we're limited to whatever the record is, whatever it was that was presented.
Yes. Yeah, and I hear that entirely. Again, I would like to think that it's unreasonable to not take the recommendation seriously from the doctor, and then again from probation and from the GAL. Further, if we're looking at back to the safety of the community issue that you brought up, again, it was not.
And I'll give you a minute too, and I'll reserve your two.
Okay, thank you. It was not until his mother was able to advocate for him at such a diligent level that he got the medication needed that actually started seeing improvement and rehabilitation in his health, and that he was having no issues after that, no outbursts after that, because there was, again, significant medical concerns that without the proper care, it's nearly impossible to actually keep impulsivity in check when there's issues with your frontal lobe, especially for a youth. So when he started receiving that care, you actually saw his behavior really change and pivot. Again, this wasn't because of the facility. This was because of his mom and counsel repeatedly pleading with the court to please order the facility to make sure his medical needs were met. So there's no reason to believe that, again, she wouldn't be able to handle the same level of care when released on probation back to Indiana, which is why those were the recommendations.
Thank you. Good morning.
This obviously, well, to quote the trial court, this is a difficult case. And I think we all recognize that, and we all realize this child does have some medical needs. And if DYS was not the appropriate place, as we have discussed a lot over the last 10, 15 minutes, that's not in the record. And to Judge Nestor, I think you brought up about how he was doing in 2020, but once he got the right medication in 2020, which was after a hearing in April of 24, within a month, he was doing extremely well 2020. He had moved from level 0 to honor levels. And so to say that
That seemed to also help with his competency. Wasn't there a
he was actually
competing
found
issue at some
competent
point?
prior to that.
Oh, he
So
was
his
found
competency was
competent
found to be
prior to that?
restored
Okay.
prior to that. And very much actually, because I handle all the competency and NGRI cases, I was thinking about those as I was doing this, and I kept looking, where are the other options? And as we said this morning, that there was an assumption that Indiana could do it, but there's nothing that says that they could.
Yeah.
And
I mean, this is sort of an interesting situation because we have had the situation where the defense presents an option, you know, sort of like an option that's not in the usual toolbox of the bench. And the bench just like, you know, tosses it aside, and then that becomes the assignment of error. And that's not what we have here.
We do not. And I know there was some talk in the appellant's brief about whether or not Judge DeGraff and Reed limited herself to believing that she only had two options. She didn't think that. I mean, when you look at this record as a whole, you know that she knows that she had a cornucopia of options. But the reality was that no matter how many legal options she had, practically, as probation said, there were two. There was the interstate compact to Indiana, or there was DYS. And
The interstate compact was, there was no, he was just on probation. There was no structure to it. Because there wasn't a residential treatment
If there was,
program.
it's not in the record.
Okay.
So when a Hamilton County judge, juvenile judge, puts somebody on interstate compact, basically, it's different than a person being on probation here. They're going to a different state where there is not that judicial control of the local probation officers.
Correct.
So how would a judge know what Indiana would be because obviously you couldn't just be on regular probation in Indiana, right?
No, I mean, in Indiana, I believe, and I believe his conviction in Indiana was for like a possession of pot. It wasn't anything serious, as these here were dealing with an F1 and an F2. Or what, an F1 or F2 if it had been committed by an adult. But I mean, obviously much more serious incidences in Hamilton County. And again, no. And you know, here, I can't actually tell you no, because it's not in the record. Maybe if there had been something in the record that said what Indiana could do, we might be having a different discussion today. But I mean, at this point, we're making assumptions on top of assumptions and
Did
guessing.
probation or anyone request more time to explore things further?
No, not that I'm aware of, not from my read of the record. I did not see that. So,
Well, whose responsibility is it then to provide these choices to the judge?
I think if a defendant is asking for something unique, that some of that burden has to at least be on the defendant.
I mean,
And
it seems like in Hamilton County, it's the probation department. Is there a statute, an ordinance, a local rule, anything that governs as to who has the responsibility to present, in a delinquency case, the options to the bench?
I, off the top of my head, I don't know. I mean, I'm sure I could find that answer.
Yeah, because that's an issue of
but
law. That's not an issue of
I don't know
fact.
the answer to that question.
Okay.
Well, it's a sentencing, and both sides are making their pitch essentially to the judge about here's what the sentence should be. And the judge has the statute with the sentencing options, and it looks like in this case was presented with two options and considered two options and concluded that DYS was one that she had more confidence in.
Yes, that is what happened here.
I mean, that's
think
what, that,
Judge-
isn't that what happens in every case at sentencing?
I believe so, but I think Judge Zias was asking if in this situation, with there being unique factors, if that put an extra burden onto the probation
Well, I'm
department.
asking really two things, is by default, who has the burden? And then beyond that, so I'm not even, I haven't gotten to the default. I know that it's probation, I know that's how it's being handled, but I don't know where that is coming from, where that is rooted in, or is it just a presumption that it's the defense? But it seems to me very peculiar to say that placement options by default are for the defense to present to the bench as to what's out there and what can work. But maybe that's the way it works, and somehow, probation is giving guidance. I just don't know, and I think that this kind of, in some ways, raises that question. This particular assignment and error, in some ways, for me at least, raises that question.
And again, to that, in this situation, probation did investigate this and did come back with the recommendation that probation, quote, "We feel like we only have two options at this time," which were either the Interstate Compact, Indiana, or DYS. So they did look into it. Now, whether or not they had to what level they had to, again, when you're looking at, well, wait, did you look at this program in Indiana, or that program in Indiana? I think at some point,
Well, I don't think the bench
default
has the,
burden-
I don't think the bench has the responsibility of being the advocate. So that's, see, that's the other calculus to that. But it's like someone has, because this is also not a criminal proceeding. Criminal
Correct.
proceeding, the defense has all kinds of burden. This is actually a civil proceeding. This is intended to be rehabilitative. This is a whole other world, right?
It is.
So I don't know if this is something that's been addressed. I don't know what governs it. And it's not presented, but in some ways that's intertwined into the argument. Would you agree with that?
I would agree that,
Yeah.
yes, that is.
So I asked appellant a lot of questions about what evidence there was in the record that DYS could not handle GT's issues. Why can't we assume that it couldn't, based on what we know about what was happening to him pre-trial, pre-sentence?
I think if anything, the record here shows that that system, whether it's 2020 or DYS, can. Again,
Well, I
because-
mean, it really couldn't. I mean, there were multiple hearings and defense counsel's correct advocacy by mom before he could get any of the treatment that he needed.
But once he got the treatment that he needed, it was successful, and it was successful in 2020.
Right, but I think there was the concern that it took so much effort and court orders to get him this treatment that, finally he has stabilized, he has improved, and now we're going to throw him into a different system, and we don't know if they can handle it, and are we going to have to come back to court a million times and get the judge to do an order and all of that?
Well,
So-
to that, I would say, we also don't know that they can't. And I have not been told that we have since gone back to the juvenile court and said, hey, this isn't working. There have been these problems at DYS, and if there are, there's mechanisms for that to be addressed. To my knowledge, it hasn't happened, but if that does happen, there are ways to address that have, to my knowledge, have not taken place yet.
So do you think in a situation like this where defense counsel is attempting to avoid DYS, they would have to put on some sort of expert or something to talk about what programs DYS has and doesn't have, and basically make the case that they can't handle what he needs? Is that on the defense to do that?
It would certainly have helped here, because then we would have answered to all the questions that we're asking this morning and all the assumptions that we're making one way or another about who can or cannot do things. We don't have any of that. And this is something where, again, if counsel felt that this was a situation where, especially when he hears that we've got two options, the Interstate Compact and DYS, well, hold on, Judge, give me a week to get some more information together for you. There are things that could have happened that did not here. And whether or not they could or should, they didn't. and that's not what's before the court today. What's before the court today is whether or not the juvenile court abused its discretion when it imposed DYS, and it did not. I mean, even probation said that was one of the two legit options that were available to this child. And it may not be a happy result, it may not be a pretty result, but it was a legal result, and it was one that the law provides for and says that there are certain cases where DYS is the right place to go. And here probation looked at it and said that was one of the two options that the court really, truly, realistically had to consider. And that obviously the appellant here does not like that choice, but that doesn't mean it was an abuse of discretion to make that choice. So unless there's any other questions, I would ask that you affirm this matter.
Thank you. You have your full 3 minutes.
Thank you, Your Honor. So just to take these in turn, first, the statute 2152.01 sets out that the juvenile system is different, right? So the goal here is the best interest of the child and community and of safety. So that's kind of when you're asking, like, where's the onus, right? And who's responsible for this? The entire system is set up in this way, right? It is different than the adult system, such that, and also that the defense counsel did present an option. It wasn't that they just presented nothing. It wasn't, we don't want DYS and nothing else. They said not DYS and probation in Indiana, which was affirmed by the probation department in Ohio, and the GAL all agreed. Further, counsel just stated that we know that DeGraff and Reed knew there were other options, but that she was maybe flippantly saying there's only two options. But we're going off of what's in the record, and there isn't she's not discussing anything else. She's saying that there are these two options and that it's only these, there's no in between, is the direct quote. There's
What
a
other
lot of
options were there?
Again, looking at any other residential facility, and at one point, the probation department does ask if they can have more time to go look into other options, but that conversation never
There
makes
weren't
it
any
back.
options at that time. You're saying she should have continued the matter to explore additional options.
Yes, or revisited the question with the probation department after asking them to go and see what other options there were, and that conversation never picks back up.
But my sense was the record indicated that local probation exhausted alternative local programs and concluded there is no program.
Of the local programs?
Right.
Sure, yeah.
And that's really what Hamilton County they would know of state of Ohio outpatient treatment programs that might be less restrictive than DYS, but they wouldn't really know about something in Indiana.
Right, which I would assume is why in April of 2024, the court asked probation to look into the matter further for what options were available in Indiana, and they said they would talk about it at the hearing the very next day, and that doesn't happen. So, again, balls were dropped certainly here. Again, we would like to go back to saying that this is unlike the adult system. It's the juvenile system that's founded upon the purposes of care and rehabilitation. And the severity of GT's medical needs warrant further exploration into what could be done for his safety. The statute also requires that dispositions have to be reasonably calculated to achieve these purposes. And again, we would say that this probation option via the interstate compact was sufficient. There's also nothing in the record that sits before us that demonstrates that GT's mother would not have been able to care for his medical needs. In fact, the opposite. It was her diligent advocacy, again, that eventually led to the facility providing him with care. And that's directly what led to GT's significant behavioral improvements, which is why you get the recommendation from probation that interstate compact probation back to Indiana makes sense for this case. Again, as such, it was unreasonable and arbitrary for the lower court to defy the record and recommendations by doctors, GAL, and probation. And today we ask this court to correct that error.
Okay, I have a little off-the-wall question here as I'm thinking through everything, okay? In your perspective, does a review of the record show that the option for Indiana was fully vetted or that it was still in flux?
For probation back in Indiana, I would say fully vetted.
Okay. Then I have no other questions.
Thank you, Your Honor.
All right. Thank you both for your arguments this morning. We'll take the matter into submission, issue a timely decision, and I wish you both a great afternoon. I have less trees today. Yesterday I had quite some trees. Yes, and that concludes our proceedings for today.